Hello, everyone, and welcome to One Civil Law, where, as always, we learn through the misfortunes of others. I'm your host on Civil Law, and we are here with two stories that recently came up in the news regarding transgender participation in sports, an issue that, of course, is notable in our culture and raises a whole bunch of interesting questions legally, according to definitions or lack thereof that various legislatures, including Congress, have provided when they define certain things and what their original meaning behind those terms is and what the rules should be. So let's just start with basic legal principles because that's always helpful. Congress gets to make choices, and some of those choices discriminate. And some of those ways of discrimination have nothing to do with people. To discriminate literally just means to choose and to choose one thing over another. Example, just to pick a random example, Congress is looking at sentencing guidelines for various offenses, and Congress is looking at all the possible offenses. Should all criminal offenses get the same exact penalty? The most logical answer to that question is no, which means that you have to discriminate. You have to choose which crimes are worse. And that can be based on a whole number of ways of measuring things. But discriminate literally just means to choose. And we do that all the time in policy when we're doing things. We're making choices based on various things. And of course, some of those choices may involve things that relate to the person themselves. For example, should a single mother get more benefits in some ways because they are a mother? Should they get more benefits to care for their child? That's a choice that you have to make. And you can make a whole bunch of policy arguments along those lines. So we make choices all the time. And some of the choices make sense and some don't. And Congress, of course, has informed us that certain choices are not permissible. To discriminate on certain things are not permissible, but to discriminate on other things are permissible. And so then you get into the question of which things are permissible, including which things about people are permissible, their status in some way. Do we give more to this person because of their status or not, or because of this characteristic or not? There's a whole bunch of choices you could make, but those are policy choices. And then you get into the question of who gets to make those decisions. And typically the answer is the legislature. So one of the things you want to look at is how the legislature has defined various things. Okay, so that's a little bit of background and a little bit of theory. Let's go into two cases that are on point, two cases that are developing in the news that surround this topic, and let's discuss some of the issues. So we have this case where a transgender athlete has won a discrimination case against USA Powerlifting in a trial court. Not nothing, but of course, there are avenues for appeal and into legal issues. This is going to be an interaction between federal law and state law and exact definitions of things and ways of looking at things. But so far, this has been the initial determination. This power lifter wants to compete in a category other than their biological sex. Should they be permitted to do that? Should anyone be permitted to do that? How do you decide what the rules are? And in law, of course, you have to have rules. Let's read a little bit more about this article. USA Powerlifting has so far lost a 2-year court battle this week after a judge ruled it discriminated against a transgender athlete by banning her from competing in women's competition. I will just take note that, of course, calling her is making a choice. The article is making a choice. The article thinks she is a her. So the article is placing her into a category by calling her. The ruling also mandated that the sports organization cease and desist from unfair discriminatory practices because of sexual orientation and gender identity, and revises policy related to sexual orientation and gender identity within 2 weeks. I feel mostly relief, Cooper said, the athlete. I think we need a win here, and it felt good to get there. Like, these things have to have meanings. These words have to have meanings, right? So how do you define her? How do you define it? Is this person a member of that category? How do you know if she's a member of that category or not? How do you know if she's a she or a her? How do you know? What is your basis for answering these questions? If the word is to have meaning, it must necessarily, by its terms, exclude. Unless you think everyone's a her, in which case the word is pointless. So, yeah. USA Powerlifting president said the organization disagrees with the court decision and will be exploring options, including appeal. Our position has been aimed at balancing the need of cis and transgender women whose capabilities differ significantly in purely strength sports. There does seem to be some difference based in biology. These differences may, in some sense, not be fair, but then, of course, nature's under no obligation to be fair. Nature doles out all kinds of things that are unfair in ways that we would all agree is probably unfair. Sometimes, for example, cancer strikes the extremely young. This is unfair. It happens. So nature doesn't always play nice. Sometimes nature does things that are not equal. There's that. Okay. Cooper's claims against USI powerlifting date to 2019 when, again, she filled out a discrimination claim with the Minnesota Department of Human Rights. In it, she claimed the sports organization violated the state's Human Rights Act by banning her and other transgender athletes from competing in women's competition. Then in 2021, through a Minnesota based advocacy group, she filed a lawsuit against them in state court. So, one of the issues that's notable here is that this might be a state law level decision, which might well be within the province of the state to make. If we're looking at this from a federalist concern, do the states have the ability to make this decision or not? Is there any federal law that preempts them or not? So, one of the issues if you were trying to decide this as a judge, would be, does federal law speak to this issue? And does it speak to an issue exclusively? So that'd be issue one. If it is, then you can completely ignore the state law. But then, of course, if the answer is no, it's not exclusive, then your next question would be, does the state law conflict with federal law? And a lot of state laws don't, including potentially this one. You'd have to actually get into it if you were deciding this for real, right? And as a judge, of course, you are not deciding what you think should be. You are deciding based on what you think the legislature has done or not done. What are the definitions? Who gets to decide? Who gets to make these decisions? So, for example, I consider myself an originalist. I consider myself someone who respects the boundaries of federal and state law. When I'm asking these questions, I'm going to ask the question and answer the questions, hopefully, ideally, the same way I would in any other area. Because it isn't based on what I want as a judge. That's the wrong way of thinking about it. The right way of thinking about it is who gets to make the decision. A judge is only determining what someone else has decided and determined if there's a conflict between those, how those conflicts should be resolved. For example, a federal versus state law. Is there federal law that speaks to this? Does it speak to it exclusively? Is there state law that speaks to this? Does it conflict with the federal law? What decisions did the federal government make? What decisions did the state government make? Are those decisions in conflict? What do the words mean on the page? Because what a woman is or is not would be decided, at least legally, by the language, because the legislature can always, of course, make their own definitions. Those definitions need not necessarily comport with any view of reality that we otherwise had. Sometimes legislatures make some very strange determinations about what does or does not fit into categories for the purposes of whatever exercise they are within the meaning of whatever law we're deciding. Sometimes those choices seem really odd. But then the question is, do they get the right to make those decisions? The answer is typically yes. And if so, if there's any rational basis for it at all, which is pretty easy, incidentally, legally, if there's any rational basis at all, then you give effect to those choices. I was fed up with the way I was being treated. I was fed up with the way my community was being treated, and enough was enough. The athlete said. Okay. Following the court win, Cooper thanked the trans women who came before her, Marsha Johnson and Stonewall riots, and the plethora of Black trans advocates and advocates throughout history. And the way they've led the fight, I'm just one small piece that's built off that. Over the last 2 years, a number of athletic bodies have announced updated policies regarding participations of transgenders, including, for example, the International Olympic Committee, which, of course, by its nature, is more international in its legal determinations. And so that raises a whole host of other problems. Anyways, so last year, of course, after record-breaking season by Leah Thomas, a transgender woman at the University of Pennsylvania NCAA, which is national in its nature, adopted a sports by sports approach for the thing. So these issues are heating up. These issues are heating up. And the issues, some to some degree, are a matter of policy. In fact, a large degree are a matter of policy. I'm not here to tell you what you should want. I'm here as a legal educator to try to determine what the people who have the right to decide have decided. And whatever they decided is the right answer, barring other considerations. The legislature gets to decide, unless, of course, it's unconstitutional, or unless, of course, it's the state government and they're violating federal law or whatever. But those are the issues. In any case, this is not the only case that is of note. Also percolating, a case that looks like it might be decided by the US Supreme Court, maybe. I bring it to your attention because it has some hallmarks of cases the Supreme Court might want to take. Now, of course, the Supreme Court doesn't need to take this and they might want to wait for another decision another day. But it does have some of the touchstones that you're looking for when you're thinking, is the Supreme Court going to take this case? It has some of those markers. So it is worthy of note as a potential candidate for those reasons. The US Supreme Court could take its first transgender sports case with an appeal from a West Virginia soccer player. West Virginia is one of 18 states that have passed some version of Save Women's Sports Act. West Virginia soccer player Lainey Amstead could give the Supreme Court's first shot at issuing a ruling on the controversial subject of transgender athletes in sports. Armstead and her lawyers from the Alliance Defending Freedom on Thursday asked the Supreme Court to weigh in on her case against the ACLU. That group is trying to strike down the West Virginia Save Sports Act, which bans male athletes who identify and present themselves as female from playing on girls' sports teams. Again, if you're thinking about this from an originalist legal perspective, you should be asking yourself the exact same question that you were before. The questions didn't change. If we're doing this in anything approaching an intellectually consistent way, the questions are the same. Has the federal government speaking to this? Is the federal government's version of this exclusive? If it's not exclusive, does the state version of this conflict with the federal law? It is possible in the first instance that both states have made decisions that are completely compatible with federal law, even though they're completely in opposite directions. Because if states get to decide, they get to decide. That's in the nature of making decisions. The federal law often leaves things to states. Sometimes the federal government speaks to things exclusively and sometimes not. And sometimes, where the federal government doesn't speak to an issue, the states will make completely different choices. So maybe both states can do what they want. Maybe West Virginia and Minnesota can do completely different things. And maybe that's legally okay. I'm not trying to tell you again what policies you should want or not. I don't do policy, I do law. When the state passed its law in 2021, it was immediately met with a lawsuit from the ACLU, which represented Becky Pepper Jackson, a transgender middle schooler who is barred from joining the school's girls cross country team. The ACLU argued the law violates the 14th Amendment and Title IX. So this is their federal hook. Does Title IX speak to this one issue? Oh, it definitely speaks to it. I'm not sure in what way, though. That's where the courts get to have all the fun. Is this a violation of equal protection? Probably not. It's probably not a violation of the 14th Amendment based on the relevant case law. Sex-based discrimination currently is treated under intermediate scrutiny, not strict scrutiny. So if you want to discriminate on the basis of race, then strict scrutiny, and good effing luck with that. If you want to discriminate on the basis of sex, intermediate scrutiny is the right answer legally right now. And sex-based sports have been around forever. So you're probably there. So not the 14th Amendment. Title IX, I mean, it's an interesting way of interpreting Title IX for sure, to say that there shouldn't be sex discrimination. Is this what Congress had in mind when they wrote Title IX? Is that what the words meant when they wrote it? These are the kind of issues you should play with. Does federal law compel this result? Okay. Armstead decided to intervene in the case on behalf of herself and other female athletes in the state by becoming a party to the lawsuit brought by the ACLU. She said that while she never dreamed this would be an issue in West Virginia. Really? Okay. She realized the ACLU could potentially threaten her own competition. Okay. I've loved soccer. I played it my entire life. I grew up playing under my dad's teams and then playing against my brothers. And I noticed from a really early age, there were a big biological difference even between me and my younger brothers. Even though I was 2 years older, he was still stronger, fitter, and faster than me, Armstead said. And whenever I heard about Connecticut lawyers or just girls losing out, I was really devastated for them because I know how much work these athletes have put into their individual sports. The Connecticut lawsuit involved three high school female track stars and field athletes who sued the state after they were forced to compete against males because they're biological males and lost out on numerous scholarship opportunities, athletic recognition, and state championship titles. The nearly 5 year litigation is ongoing, which is about roughly correct for how long it typically takes to get to the US Supreme Court. And then I heard about West Virginia Save Women's Sports Law, Armstead Stead. And whenever I had the privilege to defend it and defend all the girls and women in West Virginia from not having to play against biological males, I was excited. A district court earlier this year ruled in favor of West Virginia law, saying it's both constitutional and consistent with Title IX. And that's one of those things that's, you have some conflict. Now, it's not necessarily the kind of conflict we're typically looking for because the other one's a state level decision. This is a federal level decision. And the other one could be based on state law rather than federal law. But still, you have different things that are percolating through the courts, and you're coming to some inconsistent rulings. And some of this involves Title IX and the 14th Amendment, which is fairly important. And so you're having this issue starting to percolate. And these are not the only court decisions of note recently. The ACLU appealed the decision to the Fourth Circuit, who asked for an injunction, meaning a pause. Christina Keffer, senior attorney for ADF, said the Fourth Circuit granted the request, allowing male athletes to try out for girls' sports in a 4-page order that has no factual basis and no legal analysis. So the injunction could get appealed to the US Supreme Court, so they could decide on the injunction rather than deciding on the merits. Keffer is optimistic the Supreme Court will opt to hear the case. What the Fourth Circuit did was not only wrong as it relates to protecting fairness and equality opportunities for female athletes, but it's also wrong as a matter of law and how they went about it, and stopping the valid law with any factual or legal basis. Thursday's appeal was filed in conjunction with the West Virginia Attorney General in support of the state law. This simple law, the Save Women's Sports Act, demands that girls and women get their fair share of opportunities in sports, the Attorney General said. Another reason that you start thinking, okay, the Attorney General's getting involved. Gives a little gravitas to it. The recent injunction decision from the United States Court of Appeals for the Fourth Circuit is a minor setback, but we remain confident in the merits of our defense. We are resolute in protecting opportunities for women and girls in sports because when biological males win in women's events, as has happened time and time again, and that much I think is undisputable, female athletes lose opportunities to shine, which is very fair. So, yeah, this is interesting. These are two cases of interesting note that are percolating throughout the system. And what Title IX means when it talks about discrimination on the basis of sex and women's sports and so forth and so on is interesting. And then, of course, you have the definitional problems, which are notable. Okay, assuming that you should have women's sports as a separate category, then who gets to participate in that category? It can't be everybody because then the category is meaningless. In order for it to be a category, in order for it to be a meaningful category, it has to by its nature exclude. It can't be everybody and everything, because if it's everybody and everything, the category is meaningless. To be meaningful, it has to have limitations. And then what are those limitations? And to some degree, what should they be is a matter of policy rather than law. What they are is more of an issue of law. What they should be is a matter of policy. So when Congress wrote these things, or the Minnesota legislature wrote these things, or the West Virginia wrote these things, what did they mean? How were they defining it? Do they have the power to make those decisions? Who gets to make these decisions? What decisions did they make? And so forth and so on. So, interesting stuff for sure. And I think that probably the correct analysis, although we could go further, is that when Congress wrote sex, the term is to say that there shouldn't be discrimination on sex, first of all, implies there is such a thing as sex, because you can't discriminate on it unless it exists. It's like saying discrimination on the basis of race. You can't discriminate on the basis of race unless there is such a thing as race to discriminate on. So it must exist in some sense, because otherwise the thing is meaningless. For it to have meaning, it must refer to something. And so if sex is a thing, then what are the definitions of the thing? And how does Congress deal with the thing? And how the state legislatures deal with the thing is a very interesting thing.